Hey, estate planning attorney Paul Rabelais here, and in this video we're going to talk about what a surviving spouse must do to sell the home that that surviving spouse had previously owned with the deceased spouse. Okay, so it's not uncommon when one spouse dies for that surviving spouse. Now look, sometimes the surviving spouse wants to not do anything for a year and kind of let things settle down, and that's good advice as well. But sometimes surviving spouses tell me, no, I want to sell the house right away. And maybe they want to do that because they immediately want to move closer to children, grandchildren, or other family. Maybe they want to downsize, maybe get rid of all the maintenance issues, or maybe they're ready for a change of pace, but they want to sell the house, their spouse just died. What do they have to do? Now, state law can vary here. I'm an estate planning attorney in Louisiana, and so I'm going to really focus on that. But regardless of what state you're in, it ought to give you an idea of what a surviving spouse must do to sell their home after their spouse dies. Now, it's typical for a house to be owned by, of course, both the husband and the wife while they're both alive. And sometimes people ask me, married people or spouses ask me, well, Paul, since I own my house with my spouse, isn't it the case that if or when one of us dies, ownership just automatically goes to the surviving spouse? Well, no. Kind of here in Louisiana and in most states, nothing happens kind of quote unquote automatically. Actions need to take place. Now, I realize in some states, not in my state of Louisiana, but in some states, couples can title real estate such as their home. They can title it in both of their names, title it joint tenants with rights of survivorship. And when one spouse dies, ownership does kind of automatically go to the surviving spouse, but that's not an option here in Louisiana. So what does have to take place in Louisiana depends on a couple of things. Depends upon whether the deceased spouse had a will, and it depends on the other assets, believe it or not, that deceased spouse owned. Okay, so first, let's look at the no will options. So let's say the husband died, he died on a Monday, and on Thursday, the wife's saying, I want to sell the house. What do I need to do? So first question is, did he have a will? Let's say the answer to that is no. So now we can go down the no will path. We have to look at several different things. First, we'll look and see if his estate qualifies for what's called the Small Succession Affidavit. Applies rarely, but when it does apply, it makes things easier. So since he had no will, and if the total value of his estate is less than the paltry $125,000, which if he owned a home, or rather if he owned one half of a home, because the wife owned half, and if the value of the other things that he owned, or the other half of his community property, if the value of all of that does not exceed $125,000, then his estate qualifies for what's called this Small Succession Affidavit procedure. Judges don't have to get involved. The courts do not get involved. What will happen is all of the heirs will sign, there'll be some paperwork prepared, and all of the heirs will sign this Small Succession Affidavit. And the heirs typically will include, assuming the husband and wife had children, the surviving wife and the children. And the way it works when there's no will in Louisiana, strange words here, but as to that house, the wife keeps owning her half. As to the husband's half, she inherits this usufruct, or the right to use his half, until she either dies or remarries, whichever comes first. And his children are what's called the naked owners. They'll receive ownership of his half when the surviving wife's usufruct terminates, when she dies or remarries. So all of those heirs must sign this Small Succession Affidavit. That all gets filed in what I'll call the land records of the parish where the property is located, and it's ready to sell. Now, when it sells, because the surviving wife and the children have an ownership interest, they'll all have to sign on the sale. The money will be paid to the surviving wife because she has usufruct, she gets the proceeds of that sale, with a complicated requirement to account to those naked owners when she dies or remarries. That usufructuary accounting is a topic for another video. But first we look, if somebody doesn't have a will, we look and see if we can get things handled through the small succession affidavit procedure. If it doesn't qualify for the small succession affidavit procedure, which means, again, we're talking about no will, but the total value of the assets of the deceased spouse is in excess of $125,000, then we've got to initiate a succession, or what many people call a probate. So when we do a succession, we do it one of two ways. Sometimes we do it what's called with an administration. Sometimes we do it what's called without an administration. So with an administration, that's typically when there's lots of other assets. The probate or succession is relatively complicated. It's going to take a while. Maybe there's assets that we've got to go locate. Maybe there's something that needs to be sold right away, like the house, prior to the probate being completed. And when that's the case, when we do what's called an administration, when someone doesn't have a will, we get what's called an independent administrator appointed by a judge. So the surviving wife and the husband's kids all sign off on these pleadings and these petitions where we're asking a judge to appoint the surviving wife as the independent administrator. That may take a month or two to complete that step. And then once the judge signs the appropriate court orders ordering that surviving wife is the independent administrator of the estate of the husband, now that surviving wife can sell the house. She can sell her half because she owns it, and she can sell what was his half because she's the independent administrator of his estate. And as the independent administrator, she has the authority to sell, assets that he owned. Now, when she sells it, the check will, be payable half to the wife, half to estate of husband, and there'll be more probate matters to address once that takes place. But at least it gets her to a point where she can sell the house. Now, sometimes when there's no will and there's the small succession affidavit procedure is not permissible, then sometimes we complete a probate or a succession without an administration. When things are relatively simple, maybe all that couple owned was the house, maybe they had a joint checking account, maybe the husband had an IRA, named his wife as the beneficiary, so that's not a probate asset. Maybe they had a vehicle or two, and we don't need to do what's called an administration. Things aren't necessarily complicated. We don't have to go search for assets. It's not going to take a long time to complete the probate, relatively speaking. So we just go ahead and we make our inventories of assets. We prepare all the pleadings. With the first filing, we're asking a judge to sign the final order, ordering that the house and other assets be transferred out of the husband's name so that his half would be transferred into the wife having usufruct. His kids are the naked owners. And then once the judge signs that order, we record it in the land records of the parish where the property is located. And now the wife and kids, as the new owners of his half of the property, wife having usufruct, kids naked owners, they can sell that property. Again, proceeds will be payable to that surviving wife with a requirement that she account to the naked owners when she dies or remarries. More on that in another video. So that's the no will scenario. Now let's say husband had a will and he died, and wife's like, I gotta sell the house. What does she have to do? Well, now because he had a will, this small succession affidavit procedure, when the assets are worth less than $125,000, it is not an option. That option is only an option when someone dies without a will and less than $125,000. So now we have to examine the will that he had and look for a couple of different things. One, who are the heirs? And two, who did the husband name as the executor? Customarily, he probably named his wife as the executor. So we've got a couple of decisions to make. If things are relatively complicated and she wants to sell that house real quick, we'll go through the court process and the steps to get that wife confirmed as what's called the independent executor. So once she's confirmed, takes a month or two, then she has the authority to sell the husband's half on behalf of his estate. So she'll be able to sell the house doing that. Or if his things are relatively simple, we'll again just petition that court, petition that judge, do all the paperwork at once, have all the inventories of assets, and get a judge to sign this judgment of possession, which orders the retitling of the house. And then the surviving wife or the surviving wife and kids, depending upon the terms of his will, maybe he left the house or his half of the house to his wife outright, then she can sell it by herself. Maybe he left her usufruct and named his children as the naked owners, then they'll all have to participate in the sale. So a lot of variables there depending upon, did he have a will or not? If he didn't have a will, what's the value of what he owned? Is the small succession affidavit procedure a possibility? And then if it's not a possibility, do we need to do an administration of the estate because things are kind of complicated? And we either need to, because he had no will, get an independent administrator appointed, or yes, he had a will and get the independent executor confirmed. Or can we file all of the probate filing paperwork at once and wait for the judge to sign the final judgment of possession so that the heirs can sell that home? Now, it was a mouthful, it's a lot of stuff, but I will tell you it's probably worth mentioning, very kind of popular these days for that couple when they're putting their estate legal program in place. It is not uncommon and probably increasing in popularity because of the time and delay and complexity of having to go through lawyers and courts just to be able to get a surviving spouse to be able to sell the house. What a lot of couples do these days is they create their family living trust or revocable living trust, the husband and wife revocable living trust. What happens to the trust assets is dictated in the trust instrument, and they retitle their home into the name of their trust. So after they do that, their home is titled something like husband and wife as trustees of the husband and wife revocable living trust. Things in a trust don't have to go through any of those court proceedings when you pass away. So typically when the house is in the trust and the husband dies, the wife wants to sell the house immediately. Boy, the afternoon that he dies, she can plunk that for sale sign in the yard, and if she finds a buyer, it's ready to sell. Customarily, she would be the sole trustee of the trust after her husband died. Maybe they were co-trustees while they were both alive, but now that the husband died, she's the trustee, and kind of quite literally the day after her husband dies, she could sell that house, and nothing has to go through the courts. Judges don't have to approve anything. It really just kind of expedites and streamlines the settling of someone's estate when their assets are in the appropriate kind of trust. So that's just a little side issue to make you aware that there are avenues and vehicles available to eliminate all of the court stuff that I mentioned in the first 8 or 9 minutes of this video. So I hope all that helps. Should give you some idea. It was a mouthful, but I laid it out for you. Check with your state to see what's necessary. I'm Paul Rabelais. Make sure you turn the gray like button into a blue like button, and then hit that subscribe button and the notification bell. That way you won't miss anything as I keep producing these educational estate planning videos so you can be empowered to make better decisions for your family. We'll see you next time.